appellant, Brenda Leonard, is self-represented and is appearing by phone. Representing the appellee, Vermont Department of Disabilities and Independent Living, is Edward M. Kenny. We also have appellee Elaine Garies, who is self-represented and is also appearing by phone.
All right, very well. Ms. Leonard, can you hear me all right?
Yeah.
All right. Yeah. This is your opportunity to make your argument to the court. You have 5 minutes, ma'am. You may begin.
Okay. This has been an ongoing issue for about a year and a half. I submitted all kinds of documents on here. I'm still representing Alice Thomas and my family. I'm working on this emergency basis. As the pro se secretary, at least medical transcriptionist, and functioning as a emergency attorney, because I'm still representing Alice Thomas. She cannot hear properly sometimes. I don't know if she can get an email, and she can review like the Guardian's report. There's a Guardian's report there from 5/5/25 of this year, where I showed Exhibit A at a later time on 8/17/25. It's filed and timestamped on 9/2/25, where the house is sold belonging to Alice Thomas. I had some belongings in Brenda Leonard. It was sold for $185,000 in Exhibit A. I provided a certificate of service to everybody on that Exhibit A. I mailed it out twice, because the court said I needed a certificate of service. I mailed that first on August 17th, 25, filed on 9/2/25 with Exhibit A was the sale of the house where Carol Ladovich, the guardian, sold the house. And I would appreciate an email sent to Alice Thomas, or I sent it via mail. I served her mail and email in regards to that Exhibit A. Everyone got Exhibit A, mailed it out, so they know the house is sold for $185,000. On the Guardian's report on 5/5/25, Carol Ladovich is the guardian for Alice Thomas. I'm still representing my family and myself. And I also gave a reply brief. It was time-stamped on October 21st, 25. And in regards to this, we'd like to get, I'm Brenda Lynn, for me, Elaine, and Jim. I'm related to Alice Thomas directly. I'm also one of her daughters, and they're her children too. I would like to get an early inheritance, about $5,000 paid to me directly, sent via check in the mail. It could be sent certified mail. $5,000 for Elaine Garies and $5,000 Jim Garies as an early inheritance gift, I guess they would allow, because the Guardian already sent in May, as of that date, it's a report, it's documented right in the report. She had already spent $175,000 of Alice Thomas's money out of an estate that's valued at over $257,000 or so. It's in the Guardian's report. There's an inventory where Carol Ladovich is handling all that money, and because she spent $175,000, I think that we should be allowed to get an early inheritance gift of $5,000 apiece at least. And I was wondering, do you know how much is left in the trust account? They said it was, as of May 5th, 2025, $82,000 and $217,000 were left in Alice Thomas's trust account. I was wondering, do you know what bank that's in? Is it an actual bank? Berkshire Bank, possibly? Does she still have her checking account? I asked some questions, and I never really, unless it was stolen or lost in the mail, because sometimes my mail is stolen or lost. In regards to if there are people there, some treacherous people may have possibly stolen my mail, but I never got an answer to the statement of questions. It's also provided originally in March 18th of 2025, and then I redid it typed. Later on in August, I resubmitted that, I believe. I don't know the exact date that I have in front of me, but I did in fact submit a statement of questions. It was handwritten first on, I think, March 18, 25. I redid it. It was done. It was handwritten maybe in February, earlier time. I time-stamped it, filed it on 3/18/25,
has 1 minute
and then
remaining.
Okay, the whole point of the story is, I'm concerned as to, we're concerned as in my family where $175,000 went, and I really like and really heard from Alice Thomas paid to me directly via check. For me, 5,000. Elaine Garris 5,000. Jim Garris 5,000. I don't get emails from Scott Smith. I don't get letters from Scott Smith or anything. Carol Ledvish sent the status report and the inventories twice. That's it. I didn't get any correspondence, anything back from them. I'm concerned by how much money is sent, how much money is left over in the trust account for Alice Thomas, and as of May, it was 82,000 something, approximately. Carol Lash documents that her name is on, she's managing the account. I'd like to be a co-guardian, if I could possibly reopen co-guardian on the 329 case that I appealed, that was also dismissed. I tried one other time to get co-guardian. Okay.
Finish up your sentence, ma'am, and then your time has expired.
Okay. Okay.
All right. Well, at that point, then we will turn to the appellee. Please introduce yourself and your client. Mr. Kenny, has there been an arrangement with Ms. Gowries to divide your time?
There has, Your Honor. She is requesting the same relief that the appellant is. So, although she's technically an appellee, but I thought it might be wise to let her go first and split the time evenly. My argument will not probably take very long.
All right, Ms. Gowries, then are you prepared to make your argument or statement?
Yes, I'll sure try my best.
All right, you have 2.5 minutes, ma'am. Go ahead.
Well, when the state seized the house, I was left homeless. I was paying rent to Alice Thomas, and I used to pay her more than what she asked for in rent for a room there. And then I lost my nest egg. I've had a financial hardship because of what was going on there. And I'm still technically homeless. I've had a hardship. I'd be in the streets if I wasn't in this unusual, unique housing arrangement. But I'm in a transitional housing setting where they force your medication. Now I've gained about 50 pounds from the medication, and I'm having to replace things that clothing and with the weight gain. And the state did not allow me to collect my clothing, sneakers, or any knapsacks, warm blankets, or anything, and I had suffered in the streets without a home. Sometimes I slept on cement, and that's not safe. So I'm in this housing arrangement, but wanting to get out, because if you don't agree to their agreement here that you have to be medicated, elsewhere it wouldn't be that way, then you're out on the street the next day. And I don't like the weight gain or anything, and I visit my mother often, and every time I see her, she says she doesn't want to be in the nursing home. That's her first words to me, and she says, Elaine, when can we go back home? Because I really went all out for my mother. I used to shop on foot when the car was impounded due to my brother's activities, and the chaos there cost me my nest egg, and I wish that the court would grant the $5,000 each or some money to us each, because I'm starting off at rock bottom financially, and I'm struggling to find in this, with all the tariffs on the foods and higher costs, I'm struggling to find a good rental. And my mom always asked.
I'm going to ask you to pause your comments there. Where do we stand on the time, please?
Appellee has 2 minutes and 53 seconds remaining.
All right, so you have to wrap up your comments, ma'am, in the next 20 seconds so that Mr. Kenny can speak. Go ahead.
Okay, I wish we'd be granted the $5,000 each to make up for some losses, and the state took such a chunk of the inheritance money from us, and the whole house was sold out from under, so I had no place to rent or pay rent to, and I can't be in the streets. I was assaulted. I don't want to be killed, and I just want what's
Appellee
best
has
for everybody.
2.5 minutes remaining.
All right. Thank you, ma'am, for your argument here and your comments. Mr. Kenny, you may proceed.
Thank you, Your Honor. Your Honor, my name is Edward Kenny, Ted Kenny. I am an Assistant Attorney General representing the Department for Aging and Independent Living, State of Vermont. The facts are straightforward. Appellant Brenda Leonard is the daughter of Alice Thomas. On May 9, 2024, the Rutland Probate Division ordered the creation of an involuntary guardianship for Ms. Thomas. Ms. Leonard, subsequent to that, filed a number of motions and other documents asking the court to vacate the guardianship order, appoint her as a co-guardian, order that the proceeds from the sale of Ms. Thomas's home be distributed to Ms. Thomas and her siblings. It's being used to pay for Ms. Thomas's long-term healthcare placement that the probate court found that she needed. And also asked the court to recognize the legitimacy of a document Ms. Leonard drafted claiming to be Ms. Thomas's, quote, living will, unquote. She appealed the probate division's denial of these motions to this court deciding that there were mixed questions of law. In fact, sent it back to the civil division for appellate review. There, Rule 72 was not complied with, where the statement of legal questions, I guess I should say, was not submitted appropriately. One was submitted. That's certainly true. And secondly, the case was dismissed by the civil division. The appeal was dismissed because Ms. Leonard was seeking recognition of a living will for an incompetent person that was signed only by the beneficiary of the so-called living will. She did file, as I said, on March 18, 2025, a statement of questions. That isn't exactly clear in the civil division's dismissal, but it does appear in the record. But those questions were things like, where is Ms. Thomas's checkbook, whether the inventory that the court-appointed guardian filed had Ms. Leonard's correct name on them, and things like that. The legal issues involved are also straightforward. The civil division's dismissal of Ms. Leonard's appeal was proper for 3 reasons. First, Ms. Leonard did not file a valid statement of questions as required by Rule 72 of the Rule of Civil Procedure. Second, Ms. Leonard sought, the relief that Ms. Leonard sought is simply not available in the civil division or the probate division. And third, appellant Leonard did not brief the issues. There is precedent in this court about Rule 72. In Raid Seward's estate, 139 Vermont 623. This court upheld Superior Court dismissal of the probate appeal because a statement of questions was inadequate.
And your time has expired, sir.
And I'll rely on my briefs for the rest of it, and I thank you for your time, Your Honor.
All right. Bailiff, please call the conclusion of this matter if the appellant has no time remaining.